Hey everybody, this is Eyal. Doing a short piece. I just figured out something that I spent days on thinking about it. How to break down when the judge says that the law applies to you because you're not within the state. Wait, you're not because you're within the state, because it's easy to refute that you're within the state, but because you are in the territory that belongs to the state. Now, this is what I call a mini gish galop. Gish galop is when your opponent in a discussion or debate is drowning you in a tsunami of logical fallacies, fallacious arguments, and you got so many fallacies there that it will take you too much time to identify and relate to each one of them, and you're overwhelmed with too many logical fallacies. And we know that in trial it's really difficult to deal with so many logical fallacies. The judge is going to be like, oh well, your argument is complicated. But that's what he's doing right there when he says that you are within the territory, that's true, that belongs to the state. What he's doing is assuming three things. He's assuming there is a state, and two, the state owns the land. Three, because it owns the land, you have to obey the law, and you can be coerced to obey the law. Now, why is three a separate element and important? Because let's say I own my apartment, and in my apartment I set a rule that says, don't smoke in my apartment. Well, is it legit? Yeah, I can have a rule in my apartment and it says don't smoke, and if you light a cigarette in my apartment, I can tell you leave. But what I cannot do in my apartment is lock you up in a small room I call prison and punish you and kidnap you. These are things that are not legit. Even if I own the apartment and this is my rule, this is the rule that applies to everyone in the apartment, I cannot kidnap people and lock them in a room. Like, there's always supposed to be the option of leaving, right? Now, a country is not an apartment, because you can leave my apartment without my neighbor's permission, because you're not entering his house when you go out of my apartment. So, to say that because you are within the territory that belongs to the state, the law applies, even if there is a state, even if it owns the land, it's still not obvious that you have to obey everything they say. So there are three elements here. There is a state, it owns the land, you have to obey the laws. But before we can logically or critically discuss those three elements, there's one more thing that we must do in order to begin. Because if we don't do it, we cannot begin critically discussing those three assumptions. And it is, what does he mean by state, right? Like, how do you critically analyze an argument? Do you check whether the facts are true? No. First, you check if the conclusion is logical. If the conclusion is logical, then you go and you check the facts whether they are true or not. Now, before you can even check the conclusion, you need to understand what is the state, because they say, the state exists, it owns the land, and therefore you have to obey the laws. So the first thing you have to do is to know what is a state. After you know what is a state, you can see if the conclusion adds up to something logical, and if it does, then you have to verify the facts and see that there is really a state. So the first step would be verifying what is a state. What do you mean? What exactly do you mean by a state? Now, this is four different things, and they are compressed into one short sentence. You are within the territory that belongs to the state, therefore the law applies to you, whether you like it or not. So he's compressing four big issues into one short sentence, And we cannot waste so much time dealing with this mini gish galop. This is too big. So, in order to unpack it in a wise way, in order to diffuse the trap that is putting, what we can do is to figure out what legal tools he's using in his mind. He's using them because he knows that there are certain legal tools that he's using because he knows he is allowed to use, and we have to get into his mind and expose where he's misusing those tools. So what are those tools? Well, legal tools are, for example, judicial discretion. The judge has discretion, but the discretion has a limit. A judicial tool is, for example, taking judicial notice. But taking judicial notice is limited to a few criteria. And if we learn and we find out what they are, it is easy for us to show when he is misusing those tools. Okay, so the first and another legal tool is the presumption. Now, we will start with the presumption. There are two types of presumption, and what I'm saying is relating to the Israeli law, but I believe that it's quite the same everywhere. There are two types of presumption, basically. Let's start with legal presumption. There are two types of legal presumption. If the law says that he who is found with drugs, not for with drugs at an amount larger than 15 grams, is considered a danger to the public. Well, there is a law in Israel that says that if they find you with more than 15 grams of cannabis, it's not for self-use, and you're presumed to be danger to society. And the law says, unless you prove otherwise, unless you prove that you're not a danger. So, if you're a danger, you're being held in custody until the end of the trial. Sucks. But you have the right to prove otherwise. So, because the law explicitly says that you have the right to prove otherwise, it's called a relative presumption. They presume you are a danger, but it's relative, meaning you can prove otherwise. If the law wouldn't say that you are allowed to prove otherwise, it would be an absolute presumption or a strong presumption. I think it's called a strong presumption in English. So there are two types of legal presumption. One is a strong presumption, and the other one is a relative one. Relative presumption in the legal sense is when the law explicitly says you have the right to prove otherwise. Now, what does it mean, a presumption? A presumption to refute a presumption, or refute is not the right word. If you want to refute this presumption, it's not enough to raise a reasonable doubt, because with the legal presumption, what you need to do is you need to tilt the balance of probabilities. So you need to bring much more evidence than just enough to raise a reasonable doubt. You need to tilt the balance of probabilities. That's what the law explicitly says in Israel, and I believe it's a legal doctrine across the board everywhere. Now, there is also a factual presumption, and a factual presumption is always relative. Factual presumption is never absolute, is never a strong presumption. Let me give you an example. Now, factual... Simba, שנייה אחת, mommy. A factual presumption is something that is when it has to be based on indirect or circumstantial evidence. So, for example, let's say we're talking about a murder trial, and the murder took place in a building at 7 in the evening, and someone saw you go into that building at 5 in the evening. 2 hours before the murder. Now they can say, they presume that you were within the building at the time of the murder, because there was a person outside, he saw you getting into the building from the main entrance. He didn't saw you leave the building. Now, unless you, for example, provide some kind of alibi, or maybe you bring some evidence that shows that you jumped out of that you went out of the back door or the window, or you prove that it's not. You don't just say, I can raise a reasonable doubt. Well, there is a back door, and yes, it's locked, but you can break it and then hook up the lock again. No, I mean, my example is not that great, but I hope you get my point. A factual presumption has to be based on circumstantial evidence. I was trying to explain circumstantial evidence. I think you can understand what it is. Okay, so now we understand the 3 types of presumption the judge can be using. Two are legal, one is factual. The factual one is always relative. Now when the judge says, well, the law applies to you because you are in the territory that belongs to the state, the first thing we need to ask is, are you holding an irrefutable presumption against me? Now, holding an irrefutable presumption against you, don't be surprised, is not always a violation of your right for a fair trial, because if it's a legal, strong presumption, then yeah, he can use a strong presumption against you. There are many laws that says, well, it's a strong presumption that doing X is danger, for example, and he is allowed to presume that, and he doesn't have to give you the right to prove otherwise. And it's not a violation of your right for a fair trial. However, here's the thing. Most times the judge is going to say, no. You have the right to prove otherwise. You want to prove that the law doesn't apply? I'm open to hear your argument. He's shifting the burden of proof. But here's the thing. And we're getting to a new issue here. You can prove that the question whether the law applies to you is not a legal one. It's a factual question. And when you prove it's a factual question, then we know that the presumption is always relative because it's a factual matter. Now the judge can argue and say, no, this is a legal question. You're confusing, but it's very easy to show that it's not a legal question, it's a factual question. And Marc made a video about this recently. The best way to prove that it's a factual question is to say, well, a theoretical question is, does a fair trial require the presumption of innocence? This is because it's a theoretical question. Legal questions are theoretical questions, while practical issues are factual issues. So, for example, if I'm asking, did Eyal enjoy the presumption of innocence? Did Eyal get the right? Was Eyal granted the presumption of innocence in his trial? Now that's not a legal question. That's a factual question about what specifically happened in a specific trial to a specific person. Like the legal theory says that every person should be presumed innocent, but we're asking about this specific trial. Did the judge grant Eyal the presumption of innocence? That's a factual question, right? I mean, if you're asking, was I granted the presumption of innocence? The judge cannot say, well, every person, a fair trial requires the presumption of innocence. We already know that a fair trial requires the presumption of innocence. That's the theory. Now we're asking whether it was really granted to X person X. in trial X, in a specific trial, to a specific person, that makes it a factual question. So it is easy for us to explain and show the big difference between factual and theory, practical and theory. So then we can advance, because now we know it's a relative presumption, because it's a factual issue. Now that now that we get the judge to admit that he's holding a relative presumption, and it's a factual one, and it's very important that we show that it's a factual one, because there are two types of legal presumption. One is strong, you have no right to prove otherwise, and one is relative, you have the right to prove otherwise. But the judge is acting upon these laws because he was told these are the laws that you should act upon. And ask no question, just use these laws to read reality. And he's doing so because he's getting paid to do so. So there are two types of relative presumption. One is legal, one is factual. The legal one, he does not have to explain why he's holding that presumption. The law says so, or some legal theory says so. You have the right to prove otherwise, but I don't have to explain to you why it is so. But we can prove that it's a factual question. And factual presumption are not just relative ones. They have to be based on circumstantial or indirect evidence. So now he has to show circumstantial or indirect evidence to prove that just because you are in the territory in Tel Aviv, you have to obey the law. So we can bring him to admit that he needs circumstantial or indirect evidence that the state exists, it owns the land, and the law applies to you. Now, he can still relieve the prosecutor of that burden by taking judicial notice. That is the last tool that he has, almost the last tool that he has. So, if he wants to take judicial notice, I looked up what the law says about judicial notice in Israel, and there are three different criteria to activate or use a judicial notice. The first criteria is when it's a fact that everybody knows. When it's a factual thing that everybody knows. Right? Like, judicial notice is about evidence. So it has to be something that everybody knows, and every reasonable person knows. The second criteria is relying upon sources that are not in dispute, and he cannot probably find a source that is not in dispute, so he's going to try the first criteria and say that maybe you are not a reasonable person, but every reasonable person knows that, and I'll show you how to diffuse that one. Now, the third criteria to use judicial notice is about legal issues, and we know it's not a legal issue. So his only escape is to say, oh, it's something that every reasonable person knows. But to say that the law applies to you because you're within the territory that belongs to the state, well, it's not a fact. It's not evidence. It's a conclusion. The conclusion has to be based on evidence, on facts. And judicial notice cannot be taken in regards to conclusions. He has to break down the conclusions and to at least state what specific facts he's taking judicial notice of. And he's not going to be able to do it because he will have to invent nonsense that he was even never taught. Like, what specific facts, like you don't need to bring the facts of the witnesses, but you need to specify them if you want to take judicial notice about them. It's not going to work, right? Because he doesn't know what facts he doesn't even know what imaginary facts base his imaginary conclusions. He has this conclusion that the law applies to you. He never thought that he's going to need to invent imaginary facts to support that. He has no facts to support it, and that is the big hole that he's digging to himself. Now, even if he invents some kind of facts, I mean, if he doesn't, if he just takes a judicial notice about the conclusion and he doesn't even say what facts are supporting that conclusion, you have to object and probably to ask him to disqualify himself, because he's obviously he's obviously not giving you a fair trial, he's shifting the burden of proof, he's assuming facts that are even not explicitly he has to reveal to you what facts he's taking judicial notice of, and he doesn't even, they are concealed. He's hiding what facts he's taking judicial notice of. I mean, that's a completely violation of your due process. Now, there's one more element that I didn't touch, and probably you don't have to touch. If he says, well, I'm the judge, I can decide what is relevant and what is not, well, obviously proving relevance is easy. You can ask, if not for the applicability of the laws, would it be a violation? Blah, blah, blah. Now, let's talk about judicial discretion. Well, in Israel at least, from what I was reading, all judicial discretion is interpretative discretion. The judge has judicial interpretative discretion, which means he can interpret a legal situation or a law the way he sees fit, as long as it's within the bounds of what's deemed acceptable legal opinion. So he has the right to interpret legal issues, but he also has the discretion to interpret a factual situation. So, for example, he can interpret circumstantial evidence and to decide that it's enough in order to hold a factual presumption, right? That's one of his discretions. But his judicial discretion is interpretative, which means he cannot assume facts that are not existing, are not even explicitly revealed and claimed, right? So the judge's discretion is not an issue we have to. It's not really a deep issue. So what did we go over in this half an hour? No, 20 minutes. Well, we talked about 3 types of presumption, 2 types of legal presumption: strong and relative. Legal presumption, it just presumed so, but you have the right to prove otherwise. Strong presumption, it's just presumed so, and you can't prove otherwise. We talked about practical versus theoretical issues and how easy it is to prove that it's a factual issue. Factual presumption are always relative, and they have to be based on circumstantial evidence, and there are 3 criteria, at least in Israel. I'm sure that everywhere in the world it's just the same. You just have to find where it explicitly says those 3 criteria and know that. So you can put it to the judge in the judge's face and tell him, like, which of the 3 criteria did you just use for taking the judicial notice? And we went over the fact that judges will try to take judicial notice of conclusions instead of facts. And if they say, oh, it's something every reasonable person knows, then why does the prosecution's witnesses don't know? Aren't they reasonable people? Well, that's it. That's my breakdown of the Gish-Gallop argument position of the judge, that you are in the territory that belongs to the state. Take care until next time.